Tax foreclosures work differently. Every state, it's sort of a snowflake situation. There's lien states and deed states. If you're in a tax lien state, the government is selling a tax lien to a private investor who's going to try and enforce it and collect the taxes. And that private lien holder is the one doing the foreclosure. In a deed state, the lien never changes hands. The government holds on to the lien. The government is the one who does foreclosure, and then it sells the property outright. So if you're in one of those lien states where it's a private party actually accomplishing the foreclosure, those folks should beware, because there's a potential that a court could view them as working in concert with the state, making them a state actor and making them liable for compensation for the takings claim.
Welcome to Keys to Real Estate, the podcast for people who move the real estate industry forward. I'm your host, Mary Schuster. Well, today we're talking about something that affects every corner of the real estate transaction, but it often stays just under the radar until it's too late. Today, we're talking property rights. And joining me is David Deerson, an attorney with the Pacific Legal Foundation's Property Rights Practice Group. From cases involving eminent domain abuse to what's now widely known as home equity theft, Pacific Legal is on the front lines of defending Americans against government overreach, and their legal victories are reshaping real estate laws across the country. So whether you're working in title and settlement, if you're a real estate attorney or realtor, or if you're just someone who is simply keeping a sharp eye on how property rights shape the real estate market, this episode will give you insight into where the pressure points are, what to watch for, and what to do about it. So let's get straight into it with the terrific and dedicated legal mind of Mr. David Deerson. The presenting sponsor for this season of Keys to Real Estate is Closing Lock. Working in title, do you ever feel like you've got a target on your back? Every year, $2 trillion moves in and out of escrow accounts in the United States. Fraudsters are watching and waiting for one wrong click, one unsecured email, just one oversight. And then just like that, your client's life savings are gone. That's where Closing Lock comes in. Closing Lock provides title companies a secure, all-in-one platform to prevent fraud, protect funds, and streamline closings. Over 1 million home sales have closed safely without incident in Closing Lock. Fraudsters only have to be right once. Title companies have to be right every time. Closing Lock has your back. Visit closinglock.com today to learn more. David Deerson from Pacific Legal, welcome to Keys to Real Estate.
Thanks very much, Mary. Thanks for having me.
Well, we're so happy to have you here. Our subscribers certainly are very familiar with what PLF does, especially in the work of property rights. But we might have a couple of people who aren't familiar, who haven't been following along. So could you give us kind of the high-level overview of what you do with regard to property rights?
Yeah, absolutely. So Pacific Legal Foundation is a nonprofit public interest law firm. We were founded in 1972, so we've been doing this for a very long time. And we have a couple of issue areas that we practice in, but as you kind of hint at, property rights has always been sort of the flagship, most active area. And we mostly do constitutional litigation, and we sue the government, federal, state, and local. So we look to take cases that have the opportunity to expand constitutional legal precedents, to affirm and expand property rights.
All right. So what types of clients do you tend to represent? Is it primarily like individual homeowners, business owners? Is there a lane, or is it any property rights that are challenged?
Well, it sort of depends on the case. Our status as a nonprofit means that we're entirely donor funded, and we don't charge our clients anything. And so often people who are the best candidates for our assistance are folks who might otherwise not be able to, or have trouble paying for a private legal team. But that's certainly not the only consideration. If the case presents the right issues, we're happy to work with all sorts of clients.
Okay, that makes sense. And I'm wondering, are we in a unique era when it comes to property rights? And the reason I ask is everybody in this audience, like I said, big fans. We've all read Hernando de Soto. We all thought it was sort of baked into the cake. That is a predicate of basically all the rest of this working in it. I don't know if we've got more awareness of the challenges now, or are there more challenges? What do you think?
Well, I certainly think that you're starting to see more awareness across the political spectrum of the ways in which overburdensome regulation and interference with property rights, even from people who sort of might start out sympathetic to regulatory solutions, are seeing that there are real problems with the inability to actually use property to make private, economically useful use of your property and to build. And we were seeing that certainly with the abundance movement. We're seeing it with the YIMBY movement, which is very cross-ideological. So I do think that we're sort of entering an era where even those who wouldn't normally be especially interested in property rights are starting to realize the practical implications of all of the overburdensome regulations that we have.
I agree. There does seem to be a greater awareness, of which I applaud, because for those of us that are out working on the front lines day to day, trying to advance the ball, move the needle, you can only oftentimes get so far, and then you hit these barriers, and it's hard to solution our way out of this when we hit those sorts of brick walls.
Yeah, I think that's exactly right. And it goes back to classical economics. Friedrich Hayek talks about spontaneous order and kind of the inability of people to actually make use of their private information and their private property has made it impossible for that kind of productive, spontaneous order to do its thing.
Exactly right. Well, I'd like to start with kind of an oldie but goodie. Anybody that's coming into the world of property and real estate in general always hears about eminent domain, and then you can begin to experience it, and you can experience it in some different way. And I'd like to talk about some of the abuses. What are some of the most egregious examples that Pacific Legal has seen, conquered, pushed against? I'd love to hear some of those.
Well, it's a great question. Eminent domain is a funny thing because whether or not this is how it was intended originally, the way it exists now is that there are basically no limits on the government's power to exercise eminent domain. So if the government wants to take your property, at this point in history, there's really not much you can do to stop it. The only question is how much they're going to pay you for it. That's not intentionally how it was designed. The idea behind eminent domain was that property should be taken for a public use. But a series of cases, and most listeners will probably be most familiar with Kelo versus City of New London, but really that sort of follows from a couple of earlier cases as well. The definition of public use has been expanded so broadly that really anything the government wants to do is a public use. And so that largely means, for practical purposes, that the game is all about getting the right remuneration, getting the right compensation amount after eminent domain. Now, that's at the federal level. There certainly are some state constitutional provisions that in their text would appear to place stricter limits on what counts as a public use. Some state constitutions, for example, say that eminent domain can only be exercised when there is a necessary public use. And not all of those state constitutions have a lot of jurisprudence to expound on what they mean. And so that's one area in which there's room for litigation to kind of establish case law. This takings clause in the state constitution is written differently from the federal constitution. Let's ask the state Supreme Court what that means.
That's interesting. Thank you for anticipating the question I was going to ask, which would have been, if this is largely decided at the federal level, is there any pushback to continue to happen? And so at that state level, that's very interesting. It made me wonder, how can real estate attorneys and title professionals and even realtors, how can they look at maybe what's a yellow flag or a red flag in their area for some of these state laws that still have some play in the joints, if you will?
One easy thing to look for is, and I think a lot of listeners probably know this, but after the Kelo case, we can get into the Kelo case if you want, but I'm sort of taking it as background knowledge that the government wanted to take some private property from Suzette Kelo and give it to a pharmaceutical company to build a big campus. And the Supreme Court decided that was a public use because it would be for the purposes of economic revitalization, even though the property was going into purely private hands. I think it's the Pfizer Corporation. But after that case was decided, there was a lot of outrage, and you saw a slew of anti-Kelo statutes being passed in states around the country. And so that can be a first thing to look at, is whether, leaving aside the constitution of the state, whether there are any state statutes that describe or confine what a public use is supposed to be. I think the second thing is, people so often overlook this, just take a look at the Declaration of Rights, or often in the first section of a state constitution, see what it says about takings. You know, some state constitution, like where I live in North Carolina, actually doesn't say anything about takings at all. It has a law of the land clause, which the courts interpret to do the kind of dual purpose of a due process clause and a takings clause. Other states, like New Jersey, actually have two different takings clauses in their constitution. One that sort of describes takings from the state government, and another that describes takings exercised as a delegation of eminent domain power by corporations to whom the government gives that power. So take a look at your state constitutions. Most likely, there's not a lot of case law on this stuff, and there's certainly room to try to make some.
All right. That's a good tip. I'd like to switch over, if we could, to something that you also have been very active in, and that's the home equity theft or the excess equities takings. And certainly our subscribers are very familiar with the Tyler and Hennepin County case. For those that aren't, tell me if I've got this essentially right, David. So Ms. Tyler lived in Hennepin County and through a series of events had a delinquent tax bill of, it was $2,300, right in that 2000 range.
Initially, right.
Initially, yes. And then over time with taxes, penalties, interest, all that, 15,000. Yep.
Yeah.
So the property went to tax sale. They sold for 40,000, and Hennepin County paid themselves the 15,000 that she owed and just kept the delta, kept the difference. Does that sum it up?
Exactly right. Yeah.
Go ahead. I'd love to hear about how that case, it was a game changer, and how this ability was just sitting out there undetected.
Yeah, well, it's actually how it worked as a matter of course in about a dozen states plus the District of Columbia. And listeners can go to a website that Pacific Legal hosts called homeequitytheft.org, and they can see a map where right now the map looks pretty good. A lot of the states are in green because we've had legislative fixes in response to Tyler. But if you're able to see how the map looked when we first started working on this issue back in 2018 or so, 2017, there was a lot of states that we coded as yellow or red because either they were routinely confiscating people's equity in tax foreclosures, or they had these loopholes that made it very easy to do so. And you would think that it should work just like it does in a private mortgage. When you default on your loan to the bank sells your home, they satisfy all of the creditors, and then you get the excess. And that's also how it worked as the Supreme Court sort of went over the history in the Tyler case. That's how it worked at the beginning of the country in all of the states as well. Our research has shown that sometime around the Great Depression, I think when tax foreclosures were just cascading and coming nonstop, and it was too much of an administrative burden practically on state and local governments to go through the judicial sale, they basically gave them this shortcut and said, you know what, forget about the judicial sale. We'll just do essentially a strict foreclosure. We'll take the property and sell it and keep everything, no matter how small the tax debt. And like I said, that was routine, not only in Minnesota, but in about a dozen other states as well.
Well, and that gets to two key questions I have, because we have a lot of operational people that listen to this. So yeah, it made me wonder how many states have left to harmonize. Like I know, was it Oregon that just harmonized still this month in 2025? So I imagine we have some to go. So I'd like for you to talk about that if you could. And then also, as states are harmonizing in this cleanup process in between, is there something that real estate attorneys, title settlement folks need to be looking at? Could they get into a title problem on the next sale if the owner went through one of these negative ones and the math hasn't been netted out and the funds haven't been returned to them? Maybe that's happening as practice. I'd love for you to jam on that,
well,
please.
For the most part, it shouldn't really affect title because the issue in these kinds of cases is not that the foreclosure should not have been done. That might be the case if there was insufficient notice or some kind of due process violation or some kind of fundamental procedural flaw. But if the issue is that equity was confiscated after the fact, it shouldn't affect who holds the title. It shouldn't necessarily affect good faith purchasers of government tax deeds. So what we think it means is that the government needs to pay just compensation. Tax foreclosures work differently. Every state, it's sort of a snowflake situation. But very broadly, there are two categories of tax foreclosure procedures. There's lien states and deed states. And so if you're in a tax lien state, the government is selling a tax lien to a private investor who's going to try and enforce it and collect the taxes. And that private lien holder is the one doing the foreclosure. In a deed state, the lien never changes hands, right? The government holds on to the lien. The government is the one who does foreclosure, and then it sells the property outright. So if you're in one of those lien states where it's a private party who is actually accomplishing the foreclosure, and then it's the private party who's the only one who's ever selling the actual property as opposed to the underlying tax lien, those folks should beware, because there's a potential that a court could view them as working in concert with the state, making them a state actor and making them liable for compensation for the takings claim.
Right. But a true private owner that is not in a business model, we don't think that someone who had their excess equity taken from the state during the judicial sale or tax sale process would have to be pretty creative to try to force the issue with a true private owner.
Yeah, that's right. It shouldn't be a problem for somebody who purchased a deed to the property from the foreclosing entity. It's a problem that the foreclosing entities, whether that's municipal corporation or whether that is a private real estate investor, should be concerned about. But somebody purchasing from the foreclosing entity, that shouldn't be an issue. Their title should be good. It's not affected by the just compensation stuff.
So, and from a title insurance perspective, then I'm just thinking out loud, then if you're insuring that tax sale foreclosure process, you might care, but otherwise transactions past that should be safe and sound. All right. Do we have several states to clear up yet to harmonize, or are we mostly over the hump?
Well, most of them have been relatively quick as governments get, which might not be as quick as we'd like. There are still a couple of holdouts. Illinois comes to mind. And there are also a couple of states that seem set on taking advantage of some loopholes that still exist. So one thing worth talking about is the Supreme Court case of Nelson versus City of New York. And this case was from the 50s, and it gets discussed in the Tyler decision, but ultimately the court decides that it's sort of a different issue. They don't need to overturn it in order to rule for Tyler, and so they sort of leave it alone. But there are a lot of real problems in that decision. Basically, what it says is that as long as you give the taxpayer, the original property owner, enough procedural tools to make a claim for surplus proceeds, then if they fail to make that claim, they waive it. And so you can think of it as like a you snooze, you lose law, right? So if you don't make an affirmative claim to say, yes, I would like to retain the surplus equity in my own property, then you waive that right, and then the government or the lien holder can keep it. From a legal perspective, that is really, I think, backwards, because no amount of process can cure a taking, right? The takings clause says government shall not take property without compensation. It doesn't say anything about, well, unless it gives you enough procedure, right? There's another Supreme Court case from 2019 that Pacific Legal Foundation litigated and won, called Nick versus Township of Scott. And that case made this point very clearly. It basically said explicitly, there's no amount of process that the state can provide you that avoids their need to pay you just compensation for a taking. But nevertheless, this Nelson versus New York case stands. It has not been overturned. So states like New Jersey and Arizona, over the vigorous protests of Pacific Legal Foundation. In New Jersey, I personally showed up at the legislative task force hearings and told them not to do this. Colleagues of mine were in Arizona, and they did it anyway. Those loopholes remain to be closed. And so anybody who fails to take some affirmative step to claim their equity in New Jersey or Arizona risks forfeiting it. But those people in particular should contact Pacific Legal Foundation, because we are looking to fight that.
What's the steelman argument for the other side? Because I've not heard one, and I would love to hear it.
You know, it's a great question. One of the things I noticed after working on this issue for long enough is that basically nobody who does not have a direct pecuniary interest in this system defends it. So when you look at the amicus briefs that come in on our side, you see it from across the political spectrum. You see the Cato Institute and the ACLU,
right,
in total agreement, and right, AARP and all kinds of consumer interest groups. Yeah. When you look at the amicus papers submitted on the other side, it's almost always governments, leagues of municipalities, leagues of counties, even tax lien investing associations joined on our side, because they sort of saw, I think, the writing on the wall and just wanted to clear it up and not right, have to worry about this issue anymore. So it's really tough. I mean, if I'm making the steelman argument, I think somebody failed to pay their property taxes, and it's important to pay your property taxes, right? That's the price you pay for the state protecting your property for fire, police, all these services that most people, except for the kind of the most radical libertarians or anarchists, would agree are part of even a very limited government. You failed to pay your property taxes. You had opportunities to make late payments. You had opportunities to redeem the taxes, and ultimately the property was foreclosed. If the government is a foreclosing entity, they shouldn't have to get into the real estate business and try to make a sale for your property and try to generate enough surplus for you by finding the best sale price. That's not their job.
They're not your advocate, right?
Right,
Okay.
precisely. But there are a lot of problems with that view, if I can drop the steel man.
Yes.
First and foremost is that we see it so common that people actually are not getting proper notice in these cases. And that's really not surprising when the incentives are such that the government stands to make a huge profit from your ignorance. And so even people who may be acting in good faith, everybody is subject to incentives. And we see notice being sent to the wrong address, even when the correct address is on file. We see notice being sent to properties with no mailboxes, which the government has made the property owner promise not to occupy. We see all kinds of incorrect failures at notice and not a lot of haste to cure those failures because of the incentives. The second thing is, most people are not being scofflaws. I've talked to dozens and dozens of people who have lost their homes in tax foreclosure over the last several years. Not a single one of them thought they were getting away with anything or did this on purpose. Often it's people who don't know that they're in arrears, or they're ill, or they're experiencing an illness in the family, a death in the family. They're distracted. And so for the very same reason that they're unable to pay their property taxes in the first place, makes it very, very difficult for them to participate in all of these complicated procedures or to pay attention to notices that are sometimes just posted in newspaper of general circulation. It's unlikely that they're in a good position to fight this stuff. And so very frequently, even people who have good defenses against a tax foreclosure end up losing the property and all of their savings along with it in states that, permit home equity theft.
All right. That helps me, because for the life of me, I couldn't find an incentive for the process the way it was to go forward. But so thank you for at least taking a swing at that. And we'll keep our eye on all of that. It sounds like we're not entirely out of the woods, but it's better. And absolutely encourage anyone who has a sense of something might need to be harmonized in their area to certainly reach out to you guys. Another big push right now and focus, obviously, are inventory levels and how to balance attainable with sustainable, with solid ownership versus checking off the ownership box. And one of the things that you mentioned, the YIMBYs and the abundance folks, one of the things that we're happy to see people starting to wake up and realize about some of the barriers, the chokeholds with new housing. So what are you guys seeing out there with regard to that? And what kind of wins are we starting to accumulate, if we are yet?
Yeah, totally. Well, look, I think there's really no question, either theoretically or empirically, that burdensome regulation is a massive, massive factor in the housing shortage. One issue that we're sort of laser focused on right now, and it's partly because of how widespread this policy is and partly because of new legal avenues that we've opened up at the Supreme Court, is taking on inclusionary zoning policies, which is a nice sounding name, inclusionary zoning. It sounds like the opposite of exclusionary zoning, and exclusionary zoning is bad, but it's really a misnomer. And actually, we like to call it extortionate housing policies. And the idea behind these policies is that people who are building new residential units are made to subsidize affordable housing, either by setting aside a certain percentage of their units to be price restricted, or by paying a fee that then goes to subsidize affordable housing elsewhere. And this has become a very popular policy in a lot of different states. I think there are sort of two explanations why. There's a good faith explanation and a bad faith explanation. And I think you can kind of sniff out both. I think some people in local governments really are not especially sophisticated when it comes to policy or economics, and they genuinely think it's a nice idea and that it will help affordable housing. Then there are those folks, I think, who understand that this is actually likely to be a very counterproductive policy because it raises the costs of new housing, which is going to limit supply and therefore ultimately raise the price. But, there's a lot of NIMBY sentiment and people who don't want to see new development. For some policymakers, this is a way to actually put a stop to development while appearing as if you're trying to do something very noble in promoting affordable housing. And Pacific Legal Foundation recently had a Supreme Court victory in a case called Sheets versus County of El Dorado. And this had to do with a legal doctrine called the Doctrine of Unconstitutional Conditions, which in the case of land use, it limits the conditions that governments can put on land use permits. And actually, I'm quite proud of Pacific Legal Foundation for really putting this legal doctrine on the map in a series of Supreme Court cases since the 1980s, starting with Nolan versus California Coastal Commission. There are 4 big Supreme Court cases in this area, and Pacific Legal is responsible for 3 of them directly. And the most recent case, Sheets, expands the doctrine to clarify that it applies to even conditions on land use permits that are imposed legislatively, which for the most part is to say by city ordinance. Whereas before, a lot of jurisdictions said that it only applies to conditions that are developed on an ad hoc basis by administrators. Now it's clear that it applies to permit conditions imposed by ordinance. And that's the way that most of these inclusionary zoning policies work. There's some sort of affordable housing, inclusionary housing ordinance at the city or county level that is requiring as a condition of a residential development permit that you give up either your interest in charging a fair price or that you give up actually a fund of money. And so after the Sheets case, these policies suddenly become wide open for challenge. And they're very vulnerable to challenge based on the way that the doctrine works. If the government wants to, as a condition of granting you a land use permit, they want you to give up some property interest, which includes money. They have to make sure that the condition is designed to actually mitigate for some impact that your property is likely to have.
It needs to be specific, not general. Okay.
Precisely. So they can't say, if I'm building a property in one neighborhood that does no environmental harm, they can't say, by the way, we would like to have a butterfly reserve across town, so we'll let you build your property, but you have to pay us $1,000 for our butterfly reserve. It's got nothing to do with you, but it's our public policy. So I think the paradigmatic example of a condition that they can require is like a stormwater management system. If you're adding impervious coverage to a lot, you are going to have an impact on stormwater management. And so you can be required to give an easement for stormwater management purposes or pay money, whatever it is, as long as it's actually directly related to the impact of your development. And in the case of inclusionary zoning, the reason I think it's so vulnerable to challenge is because almost categorically, it fails that test. Because in order to pass the test, it would have to be true that building new housing units makes housing less affordable. But anybody who's taken high school econ knows supply and demand, that's totally backwards, right? Building more housing units is going to put downward pressure on prices. And so really for the same reason that it's just bad policy, it's also unconstitutional because you can't make housing more affordable by making it more costly.
By definition.
Exactly. So we've been trying to file these cases all over. We've actually seen some early success in a case in Healdsburg, California, where the city settled very, very quickly. We got a settlement offer almost immediately after we filed the case, which is, I think, a very good sign that the municipal attorneys know that these policies are really in danger and it may not even be worth going down with the ship. And so in that case, our client, Jessica Pilling, had been required to pay a $20,000 affordable housing fee just to build a single family home for her own family, which, by the way, based on their income, would have qualified to participate in the affordable housing program. So in other words, they were literally building affordable housing for a family that qualified for affordable housing, in other words, themselves. And the government wanted to charge them an extra $20,000 to subsidize other people's housing. And the settlement offer included a full refund of that $20,000, plus some money for attorney's fees and some money for delay costs. And it also included an admission that she was legally entitled to that refund. So it's not merely settling a case because it's a nuisance, but an acknowledgement that it's your money and our having charged you was unlawful. And we're filed a couple more of those cases just in the last few months. I'm actually looking forward to filing another one tomorrow that's also in California. So keep an eye on our website for our big press release about that.
Great.
But that is a major litigation priority for us. And I think it's a major policy priority given how popular these policies have become.
Well, obviously, you have to fight these fights at such a hyper-local level because that's the genesis of so much of it, that it does take a lot of time, talent, resources to spread out and find these. One of the things that I was looking at last week was, you guys, we'll put a link in the show notes too, for you guys have a search function on your website where people can look for cases in their areas, which I think is great. Encourage everybody to do that. But that got me to wondering, are there different kind of clusters of different types of cases that you're seeing around just because of what the loopholes or actual regulation law is in that area? Or I'd love for you to talk about some of the different pockets of things if you could.
Yeah, I mean, to some extent there is. Look, I think to a very large extent, there's a mimetic quality to a lot of these policy solutions. Mm-hmm. And a lot of these state and local policymakers are talking with each other. They're going to the same conferences. Mm-hmm. And so we're seeing these same solutions or maybe non-solutions implemented sort of at a local yet national level. At the same time, we're seeing a lot of state governments respond to this problem. Maybe not a lot of state governments. We're starting to see a trend in state governments responding to this problem at the state level by withdrawing some of the authority that has traditionally been delegated to the local governments. So examples in California and in Montana, to just name two examples in which there are state statutes that are designed to make it much quicker, more efficient, and add more certainty to the process of building certain sort of categorically unharmful things like accessory dwelling units that are an easy way to up to doubling the housing stock if every single family property is allowed to build one. They're great solutions for families with adult children or with elderly parents, and they're great solutions for grad student rentals, all sorts of reasons that an accessory dwelling unit or an ADU makes sense. Mm-hmm. And so we've seen some states start to try very deliberately to make it easier to build those by making it harder for cities to stop them. And I want to comment on this a little bit from a more general perspective, because I sometimes hear pushback to this coming from a place of valuing local control. And I think I understand where that pushback is coming from, but I think it's a little bit misplaced in this area. First of all, from a legal point of view, municipalities derive their powers from the state in basically the same way that the federal government derives its powers from the states, when you think back to your civics class and constitutional conventions and all of that. So I think that a lot of people have a sort of knee-jerk reaction and they think, well, I don't like it when Washington, D.C. tells me what I should do in North Carolina. So why should I like it when Raleigh, North Carolina tells me what I should do over in Wilmington?
Right.
But I think that's misplaced, first of all, for the legal reason I say, because actually it's the state that has the ultimate legal power in both situations. And secondly, because the most local form of control is at the individual level. Right? So the real question is, if I'm in Wilmington, North Carolina, why should City Hall tell me whether I can build an ADU on my property? And what these state statutes are doing is giving power back to the individual property owner rather than amassing that power in the state. So I think that's the right way to see that.
I am so glad that you walk through those nuances, because yes, I would expect, especially in our real estate professional community, with everything being so local, that I would have anticipated hearing that question first. So thanks for walking us through the thought process. I really want to talk more about some risks to the industry and increasing their awareness for attorneys and title and settlement people, what should they be watching for with regard to some of these issues? And if they wanted to become more proactive in protecting their markets from some of these abuses, what should people be watching for and doing?
That's a great question. And I think it is going to allow me to sort of tie together two of the big themes I've been talking about.
Okay.
Because, at Pacific Legal Foundation, historically, we really try to look for constitutional issues. That's our wheelhouse. When we litigate, we want to litigate based on the Constitution. Unfortunately, given the history of American constitutional law for the last 130 years or so, it's been very, very hard to find a constitutional foothold to advocate for some of these property rights when in the building space. If the government is really eliminating all economic value in your property, or if they're actually exercising eminent domain, then you have certain rights. But it's been hard to protect rights in that sort of middle level where the regulations are so burdensome, but they don't quite rise to the level of a total taking. And that's why, on the one hand, the inclusionary zoning policies are a really exciting target, because this unconstitutional conditions doctrine has given us a constitutional foothold to protect property at that sort of middle line level. The other part of it is why I think the state statutes play such a big role, because if the courts won't fix these things using the constitutional tools that they have available, because to a large extent, they've sort of buried those constitutional tools over the last century or so, there's still room for state legislatures to address these things by promoting property rights. So my advice for people in the market would be not only to keep an eye on what the state legislators are doing, but to think about creative solutions that could be political solutions in your state. So in addition to our litigation work, for example, Pacific Legal also has a legislative policy arm, and we have several model bills in the property rights space that you can find on our website that, if adopted by state legislatures, we believe would go a long way towards correcting this problem that we see at the local level with overregulation, and then at the federal level with sometimes the toothlessness of what should have been toothy constitutional solutions.
Yeah. All right. That's good. Thank you for that. I like to not only give folks information, but give them some actions they can do, because otherwise I'm just telling you about all the problems and you can't do a thing in the world to fix them. So thank you for that. I have two final questions. Is there something that when your brain hasn't quite shut off for the day, but you've left work, that you're kind of watching that maybe isn't up for litigation yet, but is there something that has your spidey sense tingling that you're interested in that we should be interested in too, maybe?
Let me give that a little bit of thought.
Sure.
This is still in the issue of land use permit conditions, but it's sort of lurking in the background of that issue. And it has to do with when these conditions are theoretically or nominally voluntary. And so the idea is that the government will say, well, you don't have to comply with this condition. We'll grant you the permit. But if you do comply, if you do give us some property, if you do price control your apartments, if you do pay for the butterfly reserve on the other side of town, we'll give you density bonuses or we'll reduce parking minimums. And I think at first glance, that sort of looks fair enough. But there's a problem lurking there that's very easily abused by setting the baseline very, very low and then allowing you to get to something reasonable merely by giving up some property. And this problem was actually signaled by Justice Scalia in the first of these cases, the Nolan case back in the 80s. It was signaled in a footnote. I think that's often been overlooked. We would love to kind of take these systems on, but I think it's a higher hanging fruit than the mandatory systems.
Sure.
So that is something that is sort of lurking in the background. What is the right case for challenging that kind of thing? Or what's the best way to message that when to a layperson or to somebody who hasn't spent a lot of time thinking about it, it might seem not only fair enough, but like a nice idea.
Right. The opt-in part of it all, it can obfuscate some of the coercion might be too strong of a word, but yeah. Oh, that is
Well, I don't know.
interesting.
The Supreme Court has used the word extortion. So
Yeah, well, there you go.
Coercion, we're on safe ground.
That's good. And I love your point about so much of this comes from good intentions that by the time they're operationalized are just non-starters. Lastly, a little birdie mentioned to me that you kind of kill it at karaoke. Can I ask you, what's your go-to? If you have one go-to song for karaoke, what is it?
Well, I always like to start with Elvis, Jailhouse Rock. When I put the collar up, I really enjoy karaoke. I usually get a couple of free drinks out of it.
Nice. You must be pretty good. Well, if we're ever in the same place, I'm going to need to see you karaoke.
Sounds like a party.
In the meantime, thank you guys for fighting the fight. We're all out here rooting for you. As I mentioned, I think at the top, cover your activities deeply because we do know that they are important for the marketplace and for some of the key principles of this country. So we'll all keep following along and you keep fighting. Thank you again for sharing time with us today.
Well, thanks so much, Mary. It's been a pleasure.
That was David Deerson of the Pacific Legal Foundation. And David, thank you so much for the terrific insights. Now, audience, I hope today's conversation gave you a new lens through which to view the deals, disputes, and development patterns we encounter in this business every day. Real estate professionals are often the first to spot the cracks when a property title suddenly gets messy, when a zoning law feels arbitrary, or when a homeowner loses far more than just land. Understanding where those cracks start and who's fighting to repair them helps all of us protect the integrity of our work and the people we serve. So to learn more about PLF's work, visit pacificlegal.org. To follow October Research's ongoing coverage of excess equity laws as states continue to adapt, our publication, The Legal Description, hosts an excess equity watch library that monitors how states are responding to the home equity theft question. So we'll include a link in today's show notes for all of that. And we'll also link you out to more information about the legal description, and its editor, Connor Howard's email address is in there too. Also, David's contact information and other resources can be found in today's show notes. So if you found today's episode helpful, consider sharing it with a colleague, leaving a review, or subscribing so you never miss what's next on Keys to Real Estate. And in the meantime, at October Research, we'll keep bringing the news and information critical to running your business because we believe that knowledge is the competitive advantage. So till next time, I'm Mary Schuster. Thanks for joining us today.